So number 3 is a biggie, and we could spend a lot of time on this, and it deserves a lot of time. So you know, this is when caffeine really helps because it's an important topic in the lease. So Nat, talk to us about your feeling about security and security deposits.
Yep. So on the surface, that security deposit is a pretty basic and simple concept, but it can get a little more involved as you do with specific leases. So the security deposit is going to be, from my perspective, really tie into the creditworthiness of the tenant, and kind of going back to the number one, the first item we talked about in terms of the parties that you're dealing with. And second, the nature of the security deposit is also important, and there's a certain nuance to it. So oftentimes they're maintained in the form of either cash or a letter of credit. And I think the most of them, I don't know your experience, George, most of them ours are cash. I happen to prefer letter of credits. And the reason why I prefer a letter of credit is if there is a situation where that particular tenant goes bankrupt, I can draw on that letter of credit without having to concern myself with the bankruptcy processes and all the litigation that is involved there. But the security deposit also ties into a lot of the things that we've already just talked about, particularly tenant improvements, surrendering. What is the tenant actually doing in the space? How much dollars did the landlord pour into that tenant in terms of the TI, or is it a unique type of TI? So for instance, you have a industrial tenant who has a very specific racking system or lift system that is going to be pretty expensive to remove. Well, they may be of I'll call it modest level of creditworthiness. When you establish that security deposit, you've got to make sure that security deposit can possibly cover the fact of your restoring your building to its pre-tenant state, if you will. So there's a whole host of considerations in identifying security deposits, not just, hey, it's just 2 months and let's go over to 1 month's worth of rent and let's go. I think it can be a much more nuanced conversation as it relates to it, and you can certainly get cute or complex with how the security deposit can have a burn down factor, depending on the credit worthiness of the tenant or whatever risk factors are going on with the tenant.
Okay. Mark, how do you feel about the guarantees and the security?
Well, representing Bank of America, we never paid a security deposit because they were the 1,000-pound gorilla. Most of my clients, though, you do pay some for them. I think the book addressed that if they have any reasonable credit, then wipe it out. And I think it's a good ask, but I don't think it's really reasonable. That's not what happens in the real world, in my opinion. So there is some sort of security deposit, and I agree with what Nat said. Depend on the risk. I represented a tenant who was I won't mention names, but a brand new startup in Jacksonville for like 30,000 feet, and they made them.
Oh, the one I referred you?
Yeah.
Only the best.
And they made them securitize their entire deal cost, the brokerage fees, the tenant improvement costs, and everything, which they had no operating record. They were a high risk, and unfortunately they ended up failing. So it was a good thing they did that. But so it's a credit issue and a deal cost issue for sure.
So there's a couple things, and Mark said it well. He's representing the 1,000-pound gorilla with Bank of America, and the landlord still wants a security deposit. So is the landlord really asking for something that's credit-based, or is he really asking for something mechanical to make his life easier, such that when Bank of America vacates the space and landlord has to spend money to do things that perhaps the tenant should have done, they've already got that cash mechanically, they don't have to bill for it, chase it. So it's really more of a logistics item than it is a credit item. And George, to you, walk us through how does a letter of credit really work?
Letters of credit are contracts between a financial institution and a beneficiary. So in the typical landlord-tenant situation, the tenant is what's called the applicant. The tenant goes to the bank and says, I need you to issue this letter of credit in favor of my landlord for for a security deposit. So the bank issues a letter of credit, which is a negotiable instrument under the Uniform Commercial Code, which means it has special powers. Basically means that the bank has to pay on it. And the letter of credit says to the landlord, upon your delivering to us the following notice, the tenant is under this lease, the tenant's in default of the lease, we have to pay you the amount of this letter of credit. So it is a contract between the bank and the landlord undertaken at the behest of the tenant. Now, Nat pointed out the most important distinction about this is that what's great about this from a landlord's perspective is that it is outside of the bankruptcy world. Because again, if the tenant just had a cash security deposit up, it's the tenant's money. The landlord is holding that essentially as what's called a bailee. That they are holding it essentially in trust for the tenant because it's not the landlord's money until the tenant defaults under the lease. And if the tenant doesn't default on the lease, the landlord has to give that money back to the tenant. So the money is truly the tenant's property from an equitable situation. The tenant ends up in bankruptcy. That security deposit is an asset of the bankruptcy estate. The trustee in bankruptcy or the tenant in reorganization in bankruptcy can say, hey, I need my security deposit back. I need that for other stuff. And you, Mr. Landlord, don't get to keep it. You're in line with my unsecured creditors, and you're going to have to work your thing out with the trustee or as part of our reorganization plan. Nat hates that because, again, if the tenant's in bankruptcy and the lease gets rejected and the tenant's not paying rent anymore and the tenant's TI is not fully amortized and the commissions aren't fully amortized and the landlord lost a lot of money on it, the landlord is an unsecured creditor in a bankruptcy, which is not the best place to be. The letter of credit is a contract between the bank and the landlord. It's not an asset belonging to the tenant. So when the tenant files for bankruptcy, the landlord can call that letter of credit, get paid, and is in a much more defensible position in most states, under most state law, which the bankruptcy court has to acknowledge, of saying the bankruptcy estate doesn't get that money. So the letter of credit is, from the landlord's perspective, preferable. So the tenant defaults, the landlord needs the security deposit, the landlord has to present the letter of credit to the bank and say, pay me. Where do you want that bank to be? Well, if I'm representing a client in Broward County, Florida, I don't want that bank to be in Chicago, Illinois. So it's really important in the security deposit letter of credit provision of the lease that you provide that the letter of credit issuing bank has to be bank, with financial wherewithal. And a lot of times I'll use the definition of a money center bank, Bank of America, Citibank, Wells Fargo, that level of bank, or a bank with a particular rating by the Office of the Comptroller. So there are different ways to qualify the quality of the financial institution issuing the letter of credit. And the second thing is, I want that bank to have offices where you can make the draw in the county where the premises are located. Because litigation over leases is what's called a local action. The proper venue for it is the county or circuit court where the property is located. I don't want to litigate the issue of whether or not I'm entitled to a security deposit in Chicago when the tenant's in Broward County and the default in Broward County. So the lease is going to provide that. You have to have a letter of credit issued by a bank that has an office, not only just an office in Broward County, but has an office where you can make the draw. Because a lot of times you just can't go to a regular branch and make the draw. You have to go to the LC department. So you want to make sure that, the best you can get this from the tenant, that the letter of credit meets those criteria. Money center banker, bank of quality that you know has got the financial wherewithal to pay you. Got an office in the county where the property is located, and that office is where you can draw the LC.
When the tenant approaches the bank, what is the bank looking for to issue that?
Collateral. This is why tenants hate letters of credit, because basically they're going to put the cash up. So what happens is I'll get a call from my client saying, hey, we're doing this deal, we're leasing the space, and we got to put up a $50,000 letter of credit for security deposit. I'm going to see a letter of credit loan agreement show up in my inbox, and I have to negotiate the terms of the tenant putting up in basically a collared or restricted account sufficient cash or credit or CDs or other high-grade security that's easily liquidatable, that the bank knows if they have to pay on the letter of credit, they can grab a pile of cash to cover them as collateral for essentially the loan they just made for the tenant to the landlord. So the bank's going to look for creditworthiness of the tenant, collateral, and again, chances are it's a relationship. Hopefully they're going to the bank they have a relationship with. So those are the basic three things you got to look out for.
Anybody else have anything on the?
And other reasons to add on the letter of credit why landlords prefer them is that it adds another layer of security, so to speak, or comfort level if they're able to get a letter of credit. That means they're probably they have the assets somewhere, they're creditworthy. And also, I can't overstate how important the type of bank that does the issues that letter of credit as well. So for how I use it, tactically is if they are okay with it and they say yes pretty quickly to letter of credit, that's a good sign that credit that tenant is in fact who they say they are.
Not that you guys would ever see this, but every once in a while, and I usually don't like to talk about the exception to the rules, is every once in a while when the landlord goes to make a draw on the letter of credit, the tenant, if the tenant's not such a nice guy, will file an injunctive action against the bank from paying on the letter of credit. Under the Uniform Commercial Code, the bank has 3 days to make the payment. So when you make the draw, the bank says, okay, I've got your draw. They're going to notify the account party, they're going to notify the beneficiary, they're going to notify the tenant. And the tenant's saying, my landlord's screwing me, or you're already in litigation with the tenant, it can happen that the tenant's going to go running to court and enjoin the bank from paying on the letter of credit, at which point the bank says, hands up, I'm going to interpolate the money into the registry of the court, and you, landlord and tenant, fight this out. That can happen. So again, not that you would ever see that, but letters of credit aren't perfect, but they are pretty darn good. And again, especially when you're dealing with a bankruptcy situation, they're much more preferable.